So tell me about the obligations on lawyers under the Act.
Okay, yes, lawyers, both solicitors and barristers, beware because you have a new and important role to play in this. And I don't mean you, I mean the legal profession out there. Solicitors have, in the first instance, have quite extensive proceedings here to, if you like, triage cases, okay, and to try to keep cases out of court, if at all possible. Okay, so before lawyers go off and issue proceedings, so initiate the court process, they are obliged to do several things. They have to advise their clients to consider using mediation and explain, obviously, what mediation is and why it might be a good idea. They have to provide information on the advantages and benefits of mediation, and on what mediation services are available and where mediation services might be accessed. They have to give clients information on the confidentiality of the process and on how to render mediated agreements enforceable. And they have to give another piece of advice, which is interesting, which was an amendment that was inserted into the Act at the last minute in the Seanad on sort of the urging of the domestic violence lobby, if you want to call them that, that the solicitor must advise the client that mediation is voluntary and may not be appropriate where the safety of the client and or their child or children are at risk. Okay, so that's a big list of things that solicitors have to inform their clients about. Not only do they have to do that, but they then have to swear a statutory obligation, a statutory declaration even on these obligations. Swear a statutory declaration verifying that they have done that. And if that statutory declaration isn't filed with the court papers, the court has to grant them an extension of time in which to meet these obligations. And as you can see, there's quite a bit to those. So, there's been a lot of discussion about this during the legislative process. So, some groups have said, well, solicitors extolling the benefits of mediation to their clients, is that not a little bit like turkeys voting for Christmas? If solicitors are dependent on getting cases into court. I think that's a little bit simplistic, to be honest. I think a lot of solicitors now recognise the benefits of selecting the dispute resolution process that is most appropriate to the needs of their clients, and do have a good awareness of mediation and its benefits. Providing information on services is a little bit more complicated because the market is still unregulated. As yet, there is no national register of mediators, so solicitors might have to do a little bit of legwork to find the most appropriate referral sources to which to send their clients. And then, of course, you have the issue that, one solicitor might suggest one mediator and then the responding solicitor might suggest somebody else. And there's a lack of clarity here as to which bodies can nominate some of their members and which can't, because some of the regulatory bodies can and some can't. So that's complex enough. Also, the fact that solicitors have to inform their clients around confidentiality and enforceability, obviously, hence the reason for this course. Solicitors will need to know what the confidentiality parameters set out in the Act are and what the mechanisms are for rendering agreements enforceable. So they will need a robust knowledge of the Act to answer to give this information to their clients and answer the questions the clients might have. One other interesting point in relation to the amendment that was inserted there around the safety of potential participants to mediation. The solicitors have had mixed views on this as well. And I know I was reading one blog where the solicitors were, a firm of solicitors was sort of saying, this is a little bit ridiculous. I'm hardly going to advise my multi-million euro commercial clients that mediation may not be appropriate if they or their children are at risk. To my mind, that's obviously a very strict interpretation of the Act and the obligations, but there is no provision in these obligations to set out sort of as appropriate. So if you're following the letter of the law, even if you're dealing with the CEO of a multi-million euro company, you will have to include that bit of advice in the in the conversation with the client that's potentially going to mediation. The bit of good news is that the Law Society's ADR committee have produced a template letter of advice to clients that incorporates all these bits of information and advice, and will of course make that template available on the resources page of this course as well.